All right. So today is part of the IEP process. We're going to talk about your rights as a parent, which also includes rights for your children as well, but mostly focusing on parent and guardian rights as it relates to the IEP process. So the first thing is that for each and every single meeting that you have for an IEP or for an evaluation or reevaluation, you will receive a copy of the Notice of Procedural Safeguards for Parents and Guardians of Students with Disabilities. It is 20 pages. It is really long and it's very jargony. It doesn't make a lot of sense. I'm going to pop it over so you can see what it looks like. And then they put out this helpful parent guide that is 232 pages to kind of explain your rights and your guides to the special education process for kids. So it's obviously not very helpful in terms of what that looks like. But for the procedural safeguards, like I said, every single time that you have an IEP, they should be giving this to you. You can always decline it and say, sorry, I've got like 50 million copies at home. I don't really need any more copies of the procedural safeguards, but by law, they have to provide it to you. So you have a copy of it so that they show due diligence of, yes, I provided this to you, so that it explains your rights as a parent or guardian. And then it kind of goes through each and every single right as a parent. So prior written notice, they have to give you written notice 10 days prior to any changes that may happen to the IEP, whether it's adding something or taking something away or revising something that's already in there. They have to provide you at least 10 days notice of that to indicate that a change is going to be made. The notice needs to be provided in understandable language. Your school or school district could also offer you the choice to provide it via email. So it's not physically sent through the mail. They can also do it electronically. And then there's your rights for parental consent, special rules for evaluation if a child was a state of the ward or ward of state, I should say. If a parent is absent and does not provide parental consent, it lets people know from the school district side what they can do moving forward for initial as well as for a reevaluation, as well as on your end, what would happen from a parent perspective. If you take away your consent, so you revoke it, what would happen from the school district side of it, your participation in meetings, what the procedure is. So it kind of goes line by line, every single right that you'll ever have as part of the process. I'll be sending this to you in an email so you have it, but you can also download it from the Illinois State Board of Ed website. And then, like I said, they put together this handy dandy parent guide back in 2020 to help explain special ed services, just special education in general in the state of Illinois. But it's 232 pages. So although it does a great job of explaining, it's not exactly an easy read in terms of like, oh, quick, I'm going to find out everything that happens with regards to the special education process. So we're going to go back to this one. So like I said, it's very jargony and long, but there are advocates and systems out there to kind of help walk you through everything. And I'm going to walk you through certain types of your rights that you should be aware of. The first one is prior written notice. I mentioned earlier that the prior written notice needs to happen within 10 days prior to the proposed or refused action and must include an explanation of the decision, the description of the evaluation procedure, sources for parents. So it needs to give an idea as to what is happening and why, you're giving notice for an IEP. It needs to happen when they initiate or change anything in the IEP or the 504. As well as when the district refuses to initiate a change or anything within the IEP or 504. One thing to note, I know a lot of your kids are very young, and so this is a very, distant thing to worry about in terms of your child turning 18. But one thing that I've come across as I'm working with kids in special education services is that they don't realize that when their kid turns 18, all educational as well as medical and financial, all rights go to that child. So regardless if your child understands their own educational rights, their own health benefits, their own, financial situations, they at the 18 become their own guardian to themselves legally. So at 18, the educational rights transfer to the student. unless otherwise determined. So one way of determining this is that parents obtain guardianship of their child to continue to provide advocacy as well as an understanding of what the student will need for their educational services past 18, or the child themselves signs a form that says delegation of rights to make educational decisions. And this is a place where they can nominate somebody. It could be their own parent, it could be a grandparent, it could be a babysitter, whoever they would like for them to make the decisions on their behalf. But the child has to sign it. So again, just keep that in mind that when a child turns 18, all educational rights transition to that child, and you have no rights yourself with regards to their educational process. 1 year prior to them turning 18, the school district is required to give you notice of that educational rights transfer. So they'll need to talk about it within the IEP that, hey, parents, just as a reminder, your child is turning 18 next year. When that happens, rights will be turned over. What are you doing with that process? Last meeting, I believe I talked about when they turn 14 and a half, they have to have a transition plan. Within that transition plan, they will start to talk about your legal rights for guardianship and things of that nature, and kind of pepper in the idea that when they turn 18, their rights are transferred over to them. But 1 year prior to them turning 18, during that IEP, they do need to, school district needs to mention to you that their rights will be transferred over at 18 to kind of help prepare you as to what would be the best decision for you and your child in terms of their rights for educational access. If there's a service that a child is supposed to be getting for their IEP, but it hasn't happened within 10 school days of the IEP being implemented, parents must also receive written notice that the service is not occurring. Say, for example, your child is supposed to be receiving speech and it's supposed to start, on this date, but it hasn't started and it's been 10 days, after this IEP was finalized. You need to have some sort of written notice to indicate that this service is not being provided, whether it's because the speech pathologist is on maternity leave and they're working on finding somebody else. They have to keep you involved in understanding what's being delivered and what's not being delivered. Some difficulties with the written notice. Sometimes we're very, we don't understand people's written language. Some people have dual languages, and we need to make sure that written notice is provided in an understandable language. So if English is not their first language that they understand proficiently, then we need to provide the written notice in a manner that they can understand. And sometimes their language that they write and read may not be the same that they're proficient in speaking. So it is on the school district to ensure that whatever we are providing to the parents with regards to any notices needs to be provided in an understandable language, because it's not fair to you if it's presented in a different language and you're like, I have no idea what I'm saying. I have no idea what this means. You have to have this presented in a way that you understand it, so you know your rights in their entirety. Parental consent. Informed consent confirms that parents are given all the relevant information in their native language again, and that they understand and agree to the activity, the evaluation, the IEP meeting, etc. Informed written consent must be obtained for initial evaluations, any placement or initial services starting, as well as reevaluation. You have to provide consent for all three items. Even if this is your third or fourth time that your child has been reevaluated, we still need to receive consent for these activities. Again, within that procedural safeguards, it does let you know what happens if you fail to give consent, and not so much that you refuse, like, no, I don't give consent to this, but you just don't respond. There are ways that the school district can continue to provide services, as well as to continue to evaluate on the best interest of the child. So, for example, for the initial evaluation, if a parent refuses an initial evaluation, the school can go through a mediation and due process. This may result in the school completing an evaluation without consent. Obviously, in everybody's best interest, it is not, I don't want to say not likely, but not a good experience to go through mediation and due process. It lengthens the time that the child is not receiving services if this is an initial evaluation. It can be lengthy on both the parent end and the school district end when everybody wants to make sure that the child is receiving what is in their best interest. But if a parent says, no, I'm not going to do an initial evaluation, I don't want my child to receive special education services, or whatever the reason is that they are refusing to give consent, school district can go through that process to act upon the best interest of the child. If the parent then, say we've already done the evaluation, but they refuse any services that are presented, then the district won't provide them. They'll just say, okay, this is what we can provide to you, but if you don't want to, you're refusing to provide consent for us to provide that, so I'm not going to provide it. This also means that the school cannot be held responsible for being in violation of the free and appropriate public education. So if you state, no, I don't want these services, I'm not going to take them, then that kind of wipes their hands clean of saying, I'm not providing services, because you indicated that you are revoking your consent to have them provide those services. You also cannot pick and choose what parts of the IEP that you want to approve and deny others. It's an all or nothing deal. However, if there's parts of the IEP that you do not, consent to, or you do not feel that this is in the best interest of your child and you don't agree with it, you can work with an advocate or get them changed. So that way, if you're not happy with the amount of minutes that your child is receiving, before going to mediation, expressing that at the IEP, I like to look at increasing the minutes that my son or daughter is receiving right now. And I feel this way because, and list out the reasons why you feel that they need more minutes, and listen with an open mind, just like they should listen to you with an open mind as to the concerns that you're bringing forth that would require that request. So even though it's kind of an all or nothing kind of package, and you can't pick and choose parts, you can still advocate for changes to be made to each individual part of itself in the IEP. And then the reevaluation, it's the same as the initial evaluation if a parent, just does not provide consent. The only difference is that the school district can just move forward with doing the reevaluation if they do not receive consent, as long as they have documented reasonable attempts to contact you to obtain this consent. Whereas with the initial, they can move forward, but they can't really move forward unless they go through mediation or due process. In the reevaluation, if they've provided reasonable attempts to contact you to obtain the consent, and they can show documented that you're just not responding to their reach outs, they can move forward with the reevaluation without having to have your consent, as well as without having to go through the mediation and due process. Reevaluations are held every 3 years. So the initial kind of sets the stage for, what the IEP will look like for the first year. And then individual assessments done by the teacher and their other service providers will be done each year to kind of just assess where their progress is, kind of similar to what our services provide here at the Academy and CPTWC in terms of providing that assessment, revising the goals. But the reevaluation for all domains that you consent to will be done every 3 years. And then you have the right at any point in time to revoke this consent. So you can decide, I don't want this anymore. I don't want my child receiving the services, or I don't want them to go to this therapeutic day school or anything of that nature. You can revoke that consent for those services by calling the IEP and just indicating like, nope, no, thank you. I don't want this anymore. Again, if you do that, if you revoke your consent, the school is no longer responsible to provide the child any services that fall under IDEA or Section 504 once that parent makes that decision. And again, they'll still be shown that, we tried to provide free and appropriate public education, but the parent, revoked that consent. So they kind of have washed our hands clean of it. But again, they can only do that, or you can only say, but they're not providing FAPE if you revoke that consent. Parent participations in meetings, you have to be allowed to participate in all meetings. Meetings should not be held without your presence. Even if you consented and say, it's okay, go ahead without me. They really should not be holding that meeting without you, because you're the voice of your child. You're there to advocate. And as I mentioned before, you're driving the bus of the process of the IEP. So you need to ensure that you are there participating. If you cannot participate on that day, then I would suggest rescheduling it. Or maybe, another parent comes on your behalf. It has to be a parent or guardian. You can't just nominate, Uncle Joe to step in for you and represent the family and things like that. We really want to make sure that the parents are the ones that are voicing and advocating for their child. This participation, so pre-COVID, a lot of the IEPs were happening in person, so that you could participate and see everybody. That's still a recommended way, so you can get to know your team members, you can see them face to face, as well as they can see you and your emotions that you're holding during this process. But other ways that you can participate is via phone or Zoom or Google. I know that CPS uses Google Meet often for their IEP meetings, so you can request that. Mostly they'll probably expect you to come in person, but if you're not able to make it in person, you can request a Zoom or a phone call. I personally prefer doing a Zoom meeting or in person. So again, the parents and you can see the team members and the team members can see you and have a fluid process for this. You must receive a written notice 10 days in advance of your meeting time, and they must tell you the purpose of this meeting, a mutually agreed upon place and time, and tell you who will be there. So even prior to actually receiving the written notice, there should be communication with you of, hey, we're going to schedule your son or daughter's IEP on such and such date at this time, and we're going to meet here. Will this work for you? That way you have an idea of like, oh, hey, this is coming and I need to, reschedule my day or take the day off from work, or how long is this going to happen, or how long is it going to take? So you can have some drive in that. You are also allowed to bring anybody that you feel has special knowledge or expertise about the child. It doesn't have to be another service provider. It could be a grandparent that knows the child really well because grandma is always home with them and they can speak to the language that they provide at home, or any sensory regulation issues that they may see. It could be an advocate. It could be one of your team members from the CPTWC. It really doesn't matter who it is, just somebody that has special knowledge or expertise about the child. They cannot deny you of that right. It would be in best interest if you let them know ahead of time, like when you're scheduling everything, hey, I'm going to bring XYZ, so that they can add them, one, to the invitation, but two, to the sign-in sheet to indicate that those individuals are there to participate and present information. An interpreter can be present, but it's also legally required if requested. So this is the tricky part about your parents' right, that if English is not your native language and you speak more fluently and proficiently in a different language, you have to request that an interpreter be there. Again, put it in writing, when you're corresponding with whoever about scheduling IEP. I would like to have an interpreter present for this. Please confirm. You can always, I do this for myself with my own daughter's 504. I always write, please confirm, afterwards, so I can make sure that I have back and forth documentation of everything that's been discussed and what is being confirmed. So that's within your rights too, to ask them to just confirm that they received this, that they understand that of your request that you're requesting for an interpreter to be present. And then translations of all documents, again, must be provided in your native language. So even though the document itself is usually in English, and because most of, I would assume, and I'm assuming widely, that most of the service providers, school teachers, and things of that nature, that English would probably be their more proficient language when writing these up. But you as a parent can request that documents be sent home in a different language, your native language, so that you can ensure that you're understanding what is written into this document. And then again, at the age of 14 and a half, there must be written notice that one of the purposes of the meeting is a transition plan. So at 14 and a half, school districts must start planning for the transition of your child. Whether that transition happens at the age of 18 when they graduate high school, or if they're going to stay on for continuing, second step of the high school year and will be leaving the day before their 22nd birthday, there needs to be a transition plan initiated at the age of 14 and a half. That way you can start talking about what your goals are, what you want them to do. have an understanding of what the process is going to look like. Each year it's going to change. At 14 and a half, it seems crazy to be planning for something, at 18 or the day before their 22nd birthday. But there are pieces that come into play each and every year after that. They're just legally to start talking about the transition plan and making sure that you understand what happens once they graduate or continuing their education further. And then you must meet once a year. You as a parent can call a meeting at any point in time in the year. The school district could come back and say, we don't need to meet formally as an IEP. We can meet, with the parent and small group of small group of providers to talk about this. But the IEP must be held once a year before it expires. So if an IEP was held today on March 20th, it will expire on March 19th, 2025. So IEP must be held prior to that date so that it's not no longer valid. And then you must have an IEP before the start of the school year. This just helps them with understanding what services your child will need, what placement would be worked out best for them, as well as accommodations and modifications. Generally, after, say that your child had an IEP at another school and now you've moved and now you're going to be, going to a different school, they will still honor that IEP that your child currently had from the other school district. But they may request to have a new one, or you could request a new one after the school year starts to make any changes that may not be valid anymore at this current school. Like maybe the child transitions into this new school district and that school district doesn't have music therapy, but it was on their IEP previously. The school district would have to let us know if they're going to provide that. If not, we need to be in agreement that this service is no longer needed, or if it is needed, then we need to work with the school district to contract out to receive music therapy. And then 3 days, school days after the meeting, the school must provide copies of all documentation. Prior to the IEP, they should be sending you a draft so you have an understanding of what is potentially going to be discussed, what goals are going to be written, evaluation results, and things of that nature, so that you have an idea before walking in as to what you're up against. But definitely 3 days at school days after the meeting, they should be providing you copies of all documentation so that you can go through and make sure that this is correct. This is what I said. This is what I requested. This was what was discussed at the IEP meeting, so that if any revisions have to be made, we can quickly call an IEP meeting to say, hey, I'm not in agreement with this. Let's move forward with talking about this even more. Evaluation procedures. Just like you should receive everything in your native language. The evaluation must be provided in the child's first language. So if English is not their first language and they have a different language that they speak, not even fluently, but they're more familiar with, that evaluation must be provided in that first language. School or parents, as we discussed the last time, can initiate the initial evaluation. If a parent is requesting it, again, everything in writing. It sounds crazy for me to just keep saying this, but I cannot stress enough. Everything must be in writing to request evaluation, to indicate that I'm not in agreement with something in the IEP, even to request an IEP meeting, I put it in writing. I trust people way too much, but it's always good to have that documentation of this is what I requested or this is what I asked and I haven't received a response. So it does require you to have an understanding of what your rights are. Once it's put into motion, that especially if a parent initiates that first evaluation, they have 14 days to make a decision about if an evaluation will occur. So the school district still has a little play in the game in terms of, I received your request, we will look at it and make a decision as to whether or not they're going to provide that initial evaluation. And then once you sign the written consent saying, yes, I agree to an evaluation procedure, the school has 60 school days to complete that evaluation. And then a reevaluation, students are reevaluated every 3 years. Keep in mind, the evaluation procedures and the reevaluation is different than an IEP meeting. They generally schedule them for the same day in terms of this is going to be the initial evaluation discussion. We're going to go through all of the evaluation results, but then they essentially close the book, open up the book on the IEP and then talk about the IEP, because that's where all of the minutes for the services, where's the service location, where are the goals going to, or what are the goals and where are they going to be held. So the reevaluation and evaluation is just basically the assessment results and everything, but it builds into the IEP. But they try to keep the meetings separate. So generally they say, we're going to talk about the evaluation results first, and then we'll talk about goals later, to keep those two processes separate. You do have the right to do what's called an independent evaluation, or independent educational evaluation, an IEE. So if you, you know, are either not trusting of what the school district is finding, or you just would rather go about it your own way and get an IEE, you can receive that evaluation from someone that you choose. And they do not need to be employed by the school district. Could be a private speech therapist, private OT, private psychologist, to indicate, you know, necessary diagnoses for services. You would be responsible for the cost. So the district would not pay for the cost of this, because the district themselves can also provide their own evaluation. You're choosing on your own to get an independent educational evaluation to show need of services for your child. On the flip side, the parents' public expense, the district pays for the evaluation, so they can receive an IE at public expense if they disagree with the findings of the evaluation. So if, you know, both of you agree that, like, oh, this didn't work out the way that we thought, the school district can pay for the IEE, but generally the district will not pay for that. There must be a written request, and the school can either agree to the request or initiate a due process hearing for those that the parents are like, I want you to pay for this, in terms of the findings of the evaluation. So generally, it's easier to go through the school district to get that evaluation process initiated. If you don't agree with the results that they provided, or you feel that your own, you know, team members can provide a better, more thorough assessment of your child, you also have that right to do an independent educational evaluation. And then private schools, children have the right to be identified and evaluated through child finds, even if they're attending a private school. So even if they have no, you know, interest in going to CPS school districts or things like that, CPS is still required to help to identify and evaluate children through child find for services. Children with disabilities are not guaranteed to be provided services in the private schools. This will be based on what the private school has accessible to their students within the schools. Private schools are generally not under the Illinois State Board of Ed, so they do not need to provide, one, services for special education, but two, they do not need to follow the law with regards to ISB for providing services for children with special needs. There are private schools that do receive federal funds, and then they can decide how they are going to allocate and provide services using those federal funds. This is why most private schools don't have special education programs, but they may be able to contract out speech, OT, PT, even social work. But they have created a contract with either CPS or other service providers to provide services within their schools, in the private schools. If the private school decides to provide services, a service plan will have to be created. It's basically an IEP for private schools, but IEPs are not, or these service plans are not legally binding. They're just basically contracts of this service will be delivered, you know, 30 minutes per week, twice a week with this child in this private school for these reasons, X, Y, Z. So it's just basically a service plan of what services are going to look like for your child. Private may also contract a service provider that will come in. This provider could also bill insurance the same way that we might bill insurance for services that were provided. But the school is not required to do this. So if you have a private speech therapist and you would like for them to come in and work with your child, that private speech therapist could bill insurance for providing services within the school. But the school is not required to, you know, provide private speech therapy. I see there's a message in the chat, and I will get to that at the very end just to make sure we have enough time to talk everything. And then you also have the rights for homeschooling. Homeschooled children with disabilities have a right to an evaluation and an IEP. The same process occurs as if you were enrolled in school. So if you're going to homeschool your students and the school district goes through the evaluation process and the IEP, they could still provide you services for, related services, other service providers, speech, OT, PT. You would just need to provide transportation to the services if it's dictated in the IEP, or if they show that they need so many minutes with the special ed teacher, you would have to provide the transportation to and from those services as is dictated in the IEP. So you still have the availability and ability to homeschool your child and still have a right to access the evaluation and IEP process through the school district, just as if you're enrolled in that school for their services. All right, complaint resolution. So if you have a complaint about your school, or you feel that your school is not upholding your rights or your child's rights to effective services, you can file a complaint with the school or with the Illinois State Board of Ed. The complaint has to be related to something that occurred within the last year. So it couldn't be like, oh, 5 years ago, I was upset about this, and so now I'm going to write a complaint. It needs to be something that's current within the last year. Once you file a complaint with either the school or ISB, within 60 days, ISB has to carry out an investigation and give the parent an opportunity to submit additional information. So this provides you, opportunity to talk about like how the rights were not being upheld, what services weren't being provided, where's your documentation of this? They really want to make sure that they're investigating on both ends. They will also ensure that the school district responds in writing to the complaint within 45 days of receiving the complaint. They also allow for the school district to resolve the complaint on their own, because again, they want to make sure that the relationship is still good between the parent and the school, so that they can resolve it. But if not, then it needs to be moved forward through a different chain of command. ISB will also review all the relevant information, and then they'll make a written notice of a decision as to the complaint, whether it's going to be resolved this way, or things are unfounded, or this is what the school claims that they're going to do. They have to write you a notice of the decision of the complaint. You also have the right to mediation. So it's designed to resolve disagreements regarding the appropriateness of special education services to children, and this will be supervised by ISB. It's free for both the school district and the parent. So a school district could take you as a parent to mediation if you're refusing to provide consent and they feel that like your child really does need these services in order to access their educational services within the school. So you're refusing to provide that consent. They could initiate a mediation process with you to see how we can work through this. It's really the bottom step of the whole process for complaints in terms of the next step will be due process. So if we can mediate, some of these with some discussions and, I'll give you this if you give me this, kind of things, then it will help to ensure that the child can move forward with services. But it's also free to you. So say you have a complaint that they're not providing you with written notice that your child hasn't received speech services for the past 3 weeks, and they were supposed to start 10 days ago or things like that after the IEP is initiated. Or say that they changed some of the goals, but we did not have an IEP process to ratify that and rectify that within the IEP to revise it. During this process, you have rights to provide your own lawyer or advocate to be present during this process to help with the discussions and things like that, because mediated agreements are legally binding. So basically anything that's discussed within the mediation and is agreed upon then becomes part of the IEP to be moved forward. They do have a policy that's called stay put. And basically what that means is whatever was the last mutually agreed upon information that will still be available to the students. So say like your last IEP stated your child's supposed to have only 15 minutes of consultation for speech services, but you're taking the school district to mediation because you really feel that your child needs 60 minutes of direct per week. The last mutually agreed upon item will still be available for the student. So let's say during the mediation process, you're able to get it to 30 minutes, and that's what you agreed upon for now. And the discussions will continue, then 30 minutes will be provided. So it's whatever was the last mutually agreed upon will still be available for a student. So they basically just kind of put a stop on whatever's in the IEP, whatever's agreed upon at that moment. And that's where we're going to move forward as we're going through this mediation process. If mediation fails, you can, on both sides, again, take the parent or the school district to due process. This is can be very lengthy and very intense because it's a legal process. So you'll be having a hearing officer who will gather evidence from the parents and the school district and make a legally binding decision on behalf of your child. Due process can occur both the district's proposal or refusal to initial or change an IEP. I've seen due processes happen where school districts have indicated that my child still needs to be in just a special education classroom, but I feel that my child needs to be moved into a therapeutic placement where they will flourish due to lower, student to teacher ratios, things of that nature. Again, everything kind of stays put in terms of what was mutually agreed upon with the last IEP process as you go through the due process. It is, basically like going to court, but you don't go into court. You kind of meet in like a conference room, but there is a hearing officer there. There are lawyers on the side of the school district. There are lawyers on the side of the parents. You have the right to call witnesses. Witnesses will be prepared with certain questions that will be asked. So it is pretty intense on both the district and the parents' side of things. I've only been through one due process with one of my students that I had at my previous job. And luckily they came to agreement prior to us having to show up to the hearing officer. But even that process was 6 months long, just preparing all the data, all the information, going through the practices of, working through the interview questions and things like that. So it can be quite lengthy to go through the due process agreement. But whatever's agreed upon during that due process, then the school district has to uphold. The school district has to contact ISB within 5 days of receiving a complaint. So again, once they hear that, like, hey, I want to take you to due process, school district has to contact ISB to let them know if this is happening. And again, quite lengthy, but can be quite helpful if you need to go that route. I wanted to share a resource with you guys called Equip for Equality. This is a nonprofit organization who advocates on the behalf of individuals with disabilities for both their human and their civil rights. They can provide self-advocacy assistance, not only for you, but also for your child to help them advocate for what they need for employers as well as school districts. They can provide legal services. They also help to make these changes and advocate on the behalf of individuals with disabilities through public policy reform to help change the laws to help them better, as well as monitoring of issues concerning human and civil rights of those with disabilities. And they also provide trainings throughout Illinois. This one, I'm going to go click here. So they provide services not only for special education, but also for employers. If somebody who is employed at a job and feels that their rights are not being upheld with regards to what they need to be successful within that job, they could talk to Equip for Equality. So there's a couple of places you can, I think there is a phone number. Let me scroll down. So there's a contact us form that you can fill out, which will send an email directly to their office in Chicago. Or you can contact their number 312-341-0022. I've had more luck using the contact us. And basically, the contact us form is like if you feel that your rights as a parent or your child's rights to educational services is not being met within the IEP process, you can send them a message and then we'll review everything. So in my experience with contacting Equip for Equality, I filled out the form and had all the information that I needed to, submit to them. They emailed me back, asked a few questions if I could provide further documentation, reviewed it again, and then they set up a phone call with me to kind of just talk about like, hey, I see your concern. This is what's happening within your legal rights. Yes, your rights are being upheld. You're okay, but this is where I feel like you need to advocate. So we're not going to move forward with providing any legal services for you on your behalf. However, this is how I would go back to the IEP or the 504 and discuss it. So it was very helpful to even because, like I said, the whole parents' rights, it's 20 pages long, lengthy, very jargony, hard to read and understand from a parent perspective. They can help spell that out for you to make sure that your legal rights are being upheld. So even if they don't formally take your case to, provide legal services for you, they'll still help you to understand, your rights are being upheld, but this is what you should do. Or even if you have a question about advocating, like I'm afraid, I want 60 minutes per week for my client, but the school district will only give me 30. These are the reasons why. Tell me how I can advocate more or what I can say. And they can help you. They'll also provide, like I said, advocacy services. So I'm going to send this link to all of you guys through the email when I do the presentation and all the documents. But it's a really good thing because they have a helpline directly for, special education themselves. But they also have information with regard to special education issues. So if you're like, I'm really confused as to conflict resolution, like what happens, or my child is going to be or has been disciplined about something and they have an IEP. What does that look like? Or why are they still being disciplined? They can't handle, their own behaviors. There's a behavior plan in place. Like why? So this can kind of help walk you through some of those things. They also have online trainings. Again, discipline is quite a hot topic for special education services because you have to really piece out, when is it a behavior concern and when is it something that the child, has full control over, and there needs to be, disciplinary action taken. Transition plans, your future after high school. What does that look like? What does transition plan even mean? They have several projects that they're working on to help underserved populations, such as charter schools, juvenile justice, Spanish-speaking families projects. There's frequently answered questions, rights information. So there's a lot of resources just within the Equip for Equality kind of background on the little page. So I'll be sure to send that to you guys so you have access to it. It's a good, just resource to have in your back pocket in case you have questions that can't be answered or you feel your rights aren't being upheld. I think, tips for parents. So again, like I said, you could bring anyone you want to any meeting. Again, they kind of say somebody who has some good knowledge about your child, but really you could bring anybody that you want to any of your IEP meetings. I just suggest that you contact the school district and let them know. So one, they're prepared for that person, coming. But two, they're also can write them on the thing on the notice as well as the sign-in sheet. It's always good to have an understanding of who's going to be there at the IEP on your behalf. You're not required to sign an IEP or a 504 when it's presented to you. Take some time to review the document before you sign. Again, they have 3 school days to present to you the finalized document so that you can review it and make sure that everything is what was discussed, what's going to be provided. It is a very long document. Some of them I've seen have been over 60 pages just because you have a lot of goals, you have a lot of information in there. Some of them even have behavior intervention plans. Some have the assessment results and things like that. So they can be a pretty lengthy document. So take some time. And especially after that meeting, even though it can only be anywhere between 1 to 3 hours, That's a long time to be sitting and talking, and the anxiety about what's going to happen with your child and the services that they're going to receive. So just take some time, take that document home, look it over, highlight things, make notes, things like that, so that you can, have a better understanding. Because once you sign off and say, yep, I agree, this is what we're going to do, then you're going to have to call an IEP revision to have any changes. So if it's not signed, it's easier for you to just make those changes. There is a sign-in sheet at the front, and they should be noting to you that this is just a sign-in sheet to indicate that you are present and participating in the IEP. It does not mean that you agree or disagree with the IEP. It just means you are sitting at that IEP meeting with them. So they should make that pretty clear to you when you're signing that attendance sheet. You can request a meeting or review at any point in time, whenever you want. Again, it's up to the school district to indicate like, hey, we just met a couple months ago. Can we just do a family meeting? Or can we just talk with these two providers to have an understanding of what needs to be changed? So regardless of when that last meeting was held, you can always call an IEP meeting. Same thing for the school district. They can call an IEP meeting at any point in time too, but again, they have to provide written notice that an IEP meeting needs to be held because changes are going to be made to XYZ. And then come prepared with your concerns. The last meeting I talked about the, pre-IEP kind of form that you should fill out, helps them write them down so that you can have an agenda, so to speak, what you want to discuss and advocate for. You don't need to share this with the school ahead of time. You don't need to present it, be like, here's all the concerns that I have, and this is what I want to discuss. Bring that with you to the IEP so you can discuss it. But that if you do present it ahead of time, it does give them a heads up of what are your top things that you want to discuss to kind of form that IEP discussion. But there is a section of the IEP, usually towards the beginning, that talks about parent concerns. And that would be a great point to make all of your concerns. But I found that it's much more helpful if parents come prepared and write down everything, because regardless if you're like, oh, there's no way I'm going to forget this. I'm always going to remember that I need this assistance or this child needs this service because of this. Write it down. Once you get in front of some of those individuals, it can get quite nerve-wracking, but always, always, always know that you run that bus. You control the process, not them. Okay, I'm going to, one thing before I get to some questions, I want to direct your attention, I guess, to ISB's page. And this is like the notice and consent form. So I just wanted to kind of go through and show you what a consent kind of looks like. If the internet will work, just so you have an idea of what it looks like, what you're going to be asking for to be signed to provide that initial consent for things. So I want to show you the consent, and then I want to also show you your written notice of, an IEP meeting, hopefully. Okay, well, while we're waiting. Okay, does charter schools fall under that private schools category? That's a good question. I need to follow up on that. I do not believe that the charter schools fall under the private school category, but I need to have a further understanding. So I'm going to write that down and I will get back to you on an answer. The next topic, not next week, because I will be traveling next week out of town. Our next meeting will be the first Wednesday of April. I will make sure to cover that information for you as to whether or not they fall under a private school category. And then the next question, where was this name? Okay. Oh, look, that's working. Let's see. Sorry, I'm reading this question. If the IEP, so it depends on if you revoked your consent to receive services. So if you revoked and said, no, I don't want your services, that kind of washes their hands clean of providing a free and appropriate public education for your child. So if like if the IEP is still valid, like it hasn't expired, but you've already said, nope, I'm not providing that, they basically have said, okay, you don't want these services. You can initiate another evaluation and say, hey, actually, I do want to, partake in some level of special education services, and indicate that you're homeschooling him right now. And then you would be responsible for travel to the school for whatever services that the IEP indicates that they would be providing. So even the 3-year reevaluation is basically just to say, like, how are they doing since the first initial evaluation, and what progress have they made on their assessments and evaluation? But the IEP is only valid for 1 year. After that 1 year, you have to have a new one done. Or if you say, no, sorry, I don't want this anymore, they could say, like, okay, then we're not going to provide this service anymore. Okay, thank you, Sarah. That's what I thought too, in terms of the charter schools are public, just because CPS does list it as an option. But I'll definitely cover that at the next one. Thank you so much, Sarah. Yep. I think also Sarah mentions that, it's good to know that your rights are to hold them are accountable. Charters are technically public schools and they are follow their own charters, but they are considered public schools. Some are better than others. I think there's a lot of schools even within CPS that are better than others. Honestly, I'm not really like for sure why that happens. I think it's just also how people allocate funds and resources and things like that to special education, as well as the type of staff members that they're hiring in, and retaining them and things like that. So everybody's experience with schools are very different. I could send one kid to one school because I'm like, yes, this is an awesome school, and they could have a very different experience because of being placed in a different classroom. So it's very nerve-wracking in this process of the IEP. But do know that you have support out there on our end to kind of help you through this process as well. Okay, so this is an initial evaluation. So it just indicates that, here's the date, the student's name, date of birth, parent's name, you're consenting. Yes, I give consent to this, or I do not give consent to collect and or review evaluation data as described on page 2 of this form. And then there's a second page that goes into, what exactly is found with the evaluation process. But this is just a formal page that they need to have signed by you, indicating that, yes, we can move forward with the initial evaluation process. There is a similar page that is a reevaluation. So instead of initial, it says reevaluation at the top, for you to give your consent for that. And again, once you sign the consent, they have 60 school days to provide the assessment and the evaluation. The nice thing about ISB is that they've really, in the past, I want to say like 10 years, have expanded how their consent forms and notices have been provided in several different languages. So it's very nice that they have really broadened that view versus when I was back in, worked at the therapeutic school, their forms are only in English and Spanish. Like those were about the only two that you could find at the time. And then let's see. Notification of a conference is another one that you'll probably come across. Hopefully it can pull up pretty quickly. Basically what this is indicating is like, when is your IEP? So I'll have the date of the notice that they're providing, the student's name, student's date of birth, the parent guardian name, the date of the IEP, the time of the IEP, and where it's located. It should be located at their school. If they haven't been assigned a school, most likely it'll be their home school that they're located at within your address. It will also provide you with contact information as to who to contact prior to the meeting so that arrangements and accommodations for participants can be made. Your IEP team should be also listed here as to who will be present, and their title of what they are. They have check boxes to indicate what you're going to be discussing at this IEP or at the revision, or if there's a functional analysis or a behavioral intervention plan that needs to be made. They will indicate by checkbox who it is. You can also request an interpreter or translated documents by contacting individuals below. So if you need to have an interpreter there, you can indicate that you can call that phone number or that person to request that. If this is not agreeable to you and you wish to review and or copy your child's school student record, you need to contact these people. So everything will be filled out, and then the person will sign off on it, indicating, we've provided you with this. They should also provide you with a copy of your procedural safeguards. Most likely, it'll provide that to you at the IEP, but sometimes it will come in mail. Again, this can be provided, mostly it comes in the mail to you, but some school districts do email in terms of like, hey, here's your thing, or they do both. They email it out to you, and then they will also send you a copy in the mail. Generally, what I have experienced working in the therapeutic day school is that we provide 3 levels of notification. We call you, we send it home to you, whether that's email or in the child's backpack, as well as send it via mail to you. So we really try to make sure that we get you 3 different ways to not only notify you, but also remind you that you have an IEP coming up. Because sometimes these IEPs are scheduled way ahead in advance. And you might not, remember, kind of like the doctor's office, they provide you with a reminder. All right, I'm going to stop the recording.